Hello, friends. Last time I promised you I would talk about appeals in criminal matters, and that's what I'm going to talk about. It seems that the majority of my clients believe that if they go to trial and lose, they can appeal. And that is true. You can file your notice of appeal, but you have to have a basis for it. And it has to be, 99% of the time, it has to be a legal error that was made by the court. An example would be this. I file a motion on your behalf to preclude certain evidence. The judge denies it. That evidence comes in, and it's pretty apparent that the jury hung their hat on that when they made a decision because of that evidence that I tried to preclude, and they found you guilty. Well, if in fact the judge made an error in the Court of Appeals in Arizona, or the Ninth Circuit U.S. Court of Appeals, if you're in federal court, determines they did in fact, or the judge did in fact make a legal mistake, then you probably would get a new trial. They could also find the judge made a legal mistake, but it would have no bearing one way or another on the jury's decision. Sometimes that's a little bit difficult to understand. They say it was harmless error. So the point of me telling you this is, you don't get two bites of the apple typically. The other way, and I'm using this term loosely, in terms of an appeal, you lose, you have 90 days from the date in which the verdict comes in, and then you're sentenced to file what's called a Rule 32 motion under the Arizona Rules of Criminal Procedure. And there's two parts of that that allow you to do that with a basis, and one would be ineffective assistance of counsel. In other words, your lawyer slept through the whole trial, or you had an alibi. Hey, I wasn't there at the time, and it could be easily proven, and your lawyer decided not to bring forward that evidence in front of a jury. That may be considered ineffective assistance of counsel. Another one is newly discovered evidence. There was something out there you never got your hands on that would show you were in another place. I mean, some physical evidence, or maybe a plane ticket or something, and you finally found it. And then you would introduce that after you were sentenced, and then the court would decide, gosh, maybe we should give this guy an evidentiary hearing to find out about this new evidence that was newly discovered. And then when they do, they could give you another trial. And a lot of times when that happens, honestly, you've been in prison for a couple of years, or if you've been in jail, you've served your time, and sort of, you may end up getting vindicated in the long run, but you've still missed a significant part of your life while this thing is all pending. Appeals on criminal matters, I assume take 2 years. Rule 32 petitions, usually resolved within a year or two. Within a year. If it's ineffective assistance of counsel, it's newly discovered evidence. It's when the newly discovered evidence was, and then a year maybe from then to run through your hearings and things. And if that's denied, then you can appeal that decision as well too. So you really don't get a second bite of the apple, in as much as a lot of people think, well, gee, if I lose, I'll just appeal it and I'll get another trial. It doesn't work like that. It's rare that a Rule 32 petition is granted, and it's rare that an appeal is granted. So the odds are totally against you that if you lose, you've got a second bite of the apple. And that's my point in explaining this to you. These are general terms, but this is what I have seen. Very few appeals are granted. Thank you.
This posted video is in no way specific legal advice on any subject. It is intended to provide general information for the public. If you need specific legal advice, call Chuck at 480-545-0700.